Hello everybody, here I am with the English Law channel. So I'm continuing with easements, one of my favourite topics in property. So looking at implied creation of easements. So this leads to either a legal or equitable easement depending on the sort of document that it's implied into. For instance, an easement implied into a legal lease is legal. If it's implied into an equitable lease, it's equitable. So simple enough. So here's implied reservations. There are two cases where easements can be applied in favour of the grantor. So there are some easements of necessity, and it really needs to be about necessity, not convenience and cost. And that happens when the land is kept by someone selling a bit, and therefore it would be worthless without an easement in its favour. That's where the dominant tenement can't get out to the road or whatever. So this transaction has in effect taken away the dominant tenement's means of access and egress. So it's wrong to think necessity is about right to drainage, or because you can lose land without drains, even if it's less convenient. So it used to be thought that implication of easements was necessary due to public policy, but after Nickerson and Barraclough 1981, the ways of necessity are implied from the common intention of the parties. An easement of necessity really is something which is defined very strictly to the existing enjoyment at the time of the grant. It can't be something you want later on. So this category, it can overlap with a different category we're going to come on to, because it's needed to use the land, and normally that's presumed to be the common intention of the parties at the time of sale. So in Adelaide International Proprietary Limited against Merton London Borough Council in 2007, it was found that there was no express reservation of right-of-way, and there was a different way the person could get in and out of his land belonging to third parties. Therefore, there was no right-of-way that could be impliedly reserved. If that's the only reasonable way of getting in and out, that's different. An unreasonable way of getting in and out would not be considered if it was climbing over a wall or doing something dangerous. Here the claimant had land bordering the A24 road, and the defendant owned the adjacent land over another road. High Path was its boundary. So the claimant couldn't lawfully get to either the A24 road or High Path without planning permission, and planning permission had been refused. So until 1989, the two plots had been owned by the same person. The claimant said he had an easement of necessity over M's land in order to access High Path. So they looked at Manjang and Drummer 1991, Nickerson and Barraclough 1991, and they said that there was no easement of necessity in this case. The other thing is common intention. These are easements which are necessary because of the common intention of the parties, as in to make that possible at the time of the grant. So the area for this, the range of this category, appears to include easements of necessity, has been very much limited by judges. Look at Poolbach Colliery Company Limited against Woodman 1915, or Ray Webb's lease 1951. So implied creation of easements through common intention is something that the courts are reluctant to do. There has to be a very strong case for that, especially where the implied reservation is disputed, like in Chafe and Kingsley 1999. As a rule of thumb, if an alleged easement is crucial to a party's common intention, then they should have set it out in black and white in the conveyance. Therefore, in the situation of implied easements, it's probable that less than a common intention, as a specific easement has been reserved, will be enough to imply reservation if there's no express reservation that the parties thought existed, and that's as per Peckham and Ellison 1999. So Wong and Beaumont Property Trust Limited 1965 is a key case on this, and you could look at its ratio decidendi. Now coming on to implied grant. So the law is more willing to imply easements by way of grant than reservation, because the seller of the land shouldn't derogate from his grant. Therefore the law is not going to easily allow the seller to imply reservations over land that he's transferred without reservations. If he wanted a reservation, he should have put it in the conveyance. That's because, like I said, you needed to have that reservation there. They wanted to keep lands over it, rights over the land. That is why implied reservations only happen through necessity, or very seldom through common intention, as I set out herein before. Now, Contrary-wise, the court is more amenable to implied grants over land when the seller retains the easements that are considered suitable to allow the buyer to use the land in the way that was bought, the way that it was envisaged when he purchased it. For not doing that would derogate from the grant the seller made in selling the land to the buyer. It would sort of defeat some of the purpose of the sale, and the seller must have realised this. So these grants sometimes, like reservations, arise impliedly through necessity or common intention. Common intention is interpreted with greater latitude, and that's not excluding the generalised common intention as to how the purchased land will be utilised, as opposed to the specific common intention about a particular easement that was intended to be reserved. Stafford and Lee, 1993, is a case about this. Lord Justice Nurse said that an easement by common intention can exist if there's a common intention between the buyer and the seller of the land about the usage of the land. The easement is necessary so that this intention can actually become a reality. So on the facts of the case, if the purchaser wishes to construct some building on the house, and the vendor sold it to him knowing that the purpose of buying the land was to build something, then the only practical access for the construction workers is over the vendor's land. So here an easement for this purpose of allowing access to constructors was created. Moreover, to necessity, this is something which is interpreted quite flexibly. Not quite as flexibly as common intention. Implied grants can come about in two more ways. So bear in mind the rule in Wheeldon and Burrows, 1879, and the Law of Property Act in 1925. There are different ways an easement can be impliedly granted, but can never be used to impliedly reserve an easement. So what is the rule in Wheeldon and Burrows? The rule in that case is where a person transfers part of his land to another person, the transfer will impliedly bear easement-like rights. These are called quasi-easements, and these are enjoyed and utilised by the transferor before the transfer, and for the benefit of the land that has been transferred, as in sold or a lease granted. These rights are called quasi-easements. They're not actual easements. Remember, quasi is as if in Latin, because there's no diversity of ownership, and these are not separate tenements. That rule in Wheeldon and Burrows is based on the principle that a grantor cannot derogate from what is granted. And that means that creating easements in these situations is not in the scope of the categories of implied easements, right? So supposing somebody's using land and he has a driveway to the house, then he sells off a bit of the land the driveway goes through. So the drive is implied into the sale of the house to be if the Wheeldon and Burrows conditions are satisfied. Now, for this rule to be valid, a number of conditions need to be satisfied. The use of the quasi-easement prior to the sale by the common owner-occupier has to be continuous and has to be obvious. So continuous here means, not every day, but regularly. So the question is whether the owner-occupier, whether it was obvious, if you could see it by looking at the land without being particularly onerous in your search. The easement must be needed to enjoy the dominant tenement reasonably. Bear in mind, this is not a strict necessity, create an easement by necessity, but for reasonable enjoyment of the land. So in this case, drainage, electricity, water pipes are included. Even the property is not landlocked. The grantee is therefore not entitled by way of necessity. The grantee can still claim it under the reasonableness rule. So in deciding whether or not the right claimed is necessary to reasonable enjoyment of the land, the courts will consider the inconvenience that will be caused to the servient owner, as in Goldberg and Edwards. If the inconvenience is too great, then the courts will say no quasi-easement. Remember, the easement has been granted by the common owner-occupier at the time of the grant, and is for the benefit of the part that it was granted to. Now, there is some dispute about whether these overlap, these requirements, and the courts have sometimes contradicted themselves on this case. Remember, the Wheeldon and Burrows principle can cause illegal equitable easement depending on what kind of transaction the easement is implied in. So the transaction is legal, is implied easement was legal. If the transaction is equitable, then the implied easement will be equitable. So the rule in Wheeldon and Burrows can be used to imply a grant of an easement. It cannot be used to impliedly reserve an easement, and that was found in Chafford Kingsley 2000. There's also implication as per section 62 of the LPA 1925. That's a mechanism through which easements can be impliedly gained and operates in two situations. The first one, which is proved many times, is about Section 62 and is applicable whether there's a dominant tenement and a servant tenement and they have a common owner, but are occupied by different people. The usual situations where the common owner has granted a lease to part of his land to a tenant. The common owner then conveys that leased land to a purchaser or grants it new lease to the tenant. The purchaser or tenant will then gain the easements or the rights that were enjoyed by the land, even those rights were licenses beforehand. I know this is where it gets rather tricky and involved. So going on a little bit. So if Section 62 was put there as a word-saving device on a conveyance, but subject to any contrary intention, it works to convert consensual privileges into easements. It seems that Parliament didn't intend this to happen, but anyway, Section 62 is vital in the way easements arise. So the requirements for Section 62 are four. First of all, this is going to be conveyance as per the LPA 1925 by deed or registered disposition. Section 62 is only applicable where the land is sold or leased by deed or registered by disposition. It can create a legal easement. Two, there's got to be a diversity of occupation between the two tenements at the time of the conveyance. The person occupying the dominant tenement is normally the lessee. Three, the right or permission must be relating to the land. Section 62 cannot convert into easement rights the things that are in their nature that can't be easements. For example, consensual privilege enjoyed by the plaintiffs in Green and Ashco Horticulturists Limited 1966. There's no contrary intention, the right being expressed as personal and just for a short time. In Wright and McAdam 1949, there was a clear example of how Section 62 works. The defendant leased a flat to Mrs. Wright and granted permission to store coal in the coal shed of the garden of that building. The lease was renewed and nothing else was said about the coal shed at the renewal, but the defendant later said you had to pay rent for storing coal in the coal shed. The Court of Appeal said that the lease was renewed. This right was really a privilege to use the coal shed would become an easement as per Section 62, because the right already existed at the time of the conveyance. If a second lease had been to a third party rather than to Mrs. Wright, or the defendant had sold the flat to a third party, then Section 2 would have given the benefit of the easement to that third party as well. In Hare against Gilman and Inskip 2000, the Court of Appeal found that permission to given to a tenement to build of a building by the landowner to park the forecourt, became an easement by Section 62 when the landlord conveyed the freehold lease of the building to the tenant. So this was following Wright and McAdam. The Court of Appeal underscored that the section would not have this effect because nobody expected the permission would be long-term. The judge said he was worried that kindness would create an obligation to the landlord that the landlord did not intend to create. That's enough from me.